The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Thursday, the 11th of February, 2016, are currently trading with gold at $1,246.26 an ounce, silver $15.76 an ounce, Texas crude $27.45 a barrel, and Bitcoin is currently sitting at about 376 U.S. currency. Today in history, Monday, February 11th, 1929, Vatican City is made the enclave, or a city-state within another state, of Rome via the Lateran Treaty. Fascist Prime Minister of Italy at the time, Benito Mussolini, agreed to giving the Catholic Church financial support in return for public support from the Pope at the time. In recent news, the four remaining ranchers, Jeff Banta, Sean Anderson, Sandy Anderson, and David Fry at the Malheur National Wildlife Refuge in Oregon, who took control of the then-empty refuge 250 miles from Portland on January 2nd, demanding the return of the lands taken by the Bureau of Land Management and the pardoning of the two ranchers convicted of terrorism for setting controlled fires, which spread to BLM lands, finally surrendered this morning after hours of negotiations with mediators. The occupation came to an abrupt end as Fry, the last to leave, threatened suicide on a live-streamed conversation with Liberty activist Gavin Seam and conservative radio host Chris Ann Hall. A phone call Wednesday night between the protesters and the negotiators was also live streamed and is available online. A jury in Estelle County, New York, convicted James Ryan today on 10 of 13 counts of vehicular manslaughter, criminally negligent homicide, and other charges, and acquitted him of the top charge of aggravated vehicular homicide. He now faces up to 15 years in prison when he is sentenced next month because his reckless driving, prosecutors say, caused a chain reaction crash. Apparently, Ryan's Toyota hit a BMW on the Long Island Expressway and then was hit by another car. A few minutes later, an SUV smashed into Ryan's car before fatally hitting a New York police officer. The results for the New Hampshire primary are as follows. For the Republicans, Donald Trump won with 10 delegates, or 35.3% of the vote. Doug Kasich was next with 4 delegates and 15.8% of the vote. Ted Cruz, 3 delegates and 11.7% of the vote. Followed finally by George Bush with 3 delegates, 11%, and Mark Rubio with 3 delegates, 10.6%. For the Democrats, Bernie Sanders won 60.4%, or 15 delegates, while Hillary Clinton only got 38%, or 9 delegates. This is your lowdown for February 11th, 2016.
What you gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father, you chuck it on your brother and you chuck it on your sister, you chuck it on that one and you chuck it on me. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do?
Okay, howdy. This is Randy Kelton, Rule of Law Radio on this Friday, the 12th day of February 2016. And last night we did about an hour on how to write legal documents. And frankly, that wasn't enough. So I'm going to go back into this. I'm trying to get rid of some of that accent. I'm going to go back into some of this, and I'm trying to develop a cogent presentation. Now, I will be presenting a lot of issues. Don't try to memorize them all. Don't try to, not even necessary to try to understand them all. I'll go through them and try to go through them in a way such that when you come across them, they will be something that you recognize, especially when you're writing a document for a specific purpose. These will help you to make the document more readable and more effective. Now, here we're speaking to writing legal documents. Now, when you write documents in particular, your purpose is to affect the mind of the reader and bring the reader to a specific state of mind. If it's an adventure story, if it's a mystery, those are different states of mind. When you're writing legal documents, you want to bring the person to your position. And one of the first things to understand about how to effectively write a legal document is flow, the concept of mental flow. Now, this actually goes to anything that you write. Reading is probably the most hypnotic thing anyone will ever do. And the better the writing, the more hypnotic it is. Everybody's had the experience of reading a novel or a story and just falling into the storyline. And then a couple hours later, you come back up for air. Those are documents that the writer has taken great care not to knock the reader out of flow. And any time when you're reading something, if you notice the writer as opposed to the content, then the writer's made a mistake. He screwed up. A lot of times writers will put in a really fancy, nice turn of phrase because they think the language really sounds cool. It makes them feel smart and professional. Well, it may make them feel good. But if it kicks the reader out of flow, if the reader notices the turn of phrase, then he's done the reader a disservice, and he's also done his intended outcome a disservice, because when you drop out of flow, you tend to lose where you're at. I'm going to go first through some things to avoid. There are certain structures that human beings tend to trip over. And when you're writing a document for a specific purpose, you want your reader focused on the purpose. You don't want them having questions in their mind that aren't answered. You don't want them having to read a sentence 2 or 3 times to understand what it means. You don't want anything that will trip them up or cause a pattern interruption. So one of the first things that we try to avoid, one of the more common things that we do when we're writing this kind of document, are conjunctions. We overuse conjunctions. We have this point we're trying to lead our reader to, and we start putting in these statements, facts, and law that will lead the reader to this particular point. And we have a tendency not to trust our reader. So we say, this is the case, and 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 therefore that's the case. The reader does not have a clue as to what you are talking about. Because each time you use a conjunction, that implies that this first independent clause is intrinsically connected to the second independent clause. If you have 2 independent clauses, you want to put them in separate sentences, because the reader will get it much better if you say, this is a fact, and then you say, this here is a fact, and this is a fact. Therefore, with this fact, and this fact, you must come to this conclusion. If you break your sentences in your clauses into separate sentences instead of connecting together with conjunctions, the reader will be able to develop an understanding much better. I'm guilty of this myself because I really want the reader to get this point, and I'm kind of afraid to put a period in there and stop the train of thought so that I can move to the next piece. I want to make sure that the reader understands that they're intrinsically connected together, and sometimes I make my reader nuts. I was reading a document the other day that had huge paragraph, 1 sentence. No human being can make sense of that. Too many pieces to try to put together. A human being can only hold in their conscious awareness 7 plus or minus 2 discrete pieces of information at one time. We try to stuff more than that in there without giving them a break, they're going to start losing information. Okay. Conjunctions. Avoid conjunctions whenever you can, or the overuse of conjunctions. Pronouns. Avoid, in a legal document, avoid pronouns like the plague. When you write a document for legal consumption, you have an opposing counsel whose job it is to misconstrue everything you say, to tear your document apart and make it as ineffective as possible. So if you use pronoun, and there's any way that the referential index to that pronoun can be misconstrued, the lawyer will deliberately misconstrue it. Okay, maybe he won't. But you should conduct yourself when preparing legal documents as if the lawyer on the other side will do everything in his power to trash your document. So exercise caution, and one thing that will eliminate a lot of problems is the elimination of pronouns. And then there are two specific terms that we tend to use a lot in language, and one is a term we misuse. The other one is a term that we don't always need. The is, for the most part, if you can't define a word, don't use it. As you're writing a documents, every once in a while you should look at words you think you know and look them up. Ask yourself, one of the most common terms we use in writing, what does it mean? I have crashed my system. It seems like I had a definition of it here. The essentially means one previously mentioned. So when we're writing a document, if we're speaking to an issue that we haven't referenced earlier, and we use the term the lacks referential index. It lacks something specific that it's referring to. And if you're writing it as a legal document, the lawyer on the other side is going to get that and twist it out of shape as much as he possibly can. He's going to deliberately assume that the term the refers to something previously mentioned that you did not intend. So avoid it if you can. The other term is that. Now that is a word it's a directive word. It's a word that directs a listener. It's most effectively used in spoken language. It's because we speak approximately 300 words a minute. Unless you're from New England or something, then you probably speak 350 to 400. I have trouble. You hear me on the air sometimes telling people they're talking faster than I can listen. But we speak quickly, so we need directing terms. Brady, President Reagan's press secretary, the one that was shot when in the assassination attempt on Reagan, he would get an article from one of his press attachés and go through the article and strike out the word that every time he came across it and give it back to him and have them rewrite it to take it out. I found in my own writing that very often, if I take out the word that and do nothing else, the reader will put it right back. This is what I'll speak to later if we have time. What I refer to as a conversational ellipsis. Conversational ellipsis is where you leave out part of a sentence. You leave out a phrase. We have these pat phrases we regularly use in language. And in the spoken language, we need them primarily to give us direction. Often in the written language, if you leave it out, the mind will put it right back. And that is one of those terms where if you leave it out, the mind will put it right back. You won't even notice it wasn't there. And when that inner part of the mind becomes engaged in the process, becomes engaged by putting that word back without alerting your conscious awareness, that creates a phenomenon we call rapport. And I will speak to rapport when we come back on the other side. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking about how to write legal documents. At this point, I'm talking about how to maintain mental flow. And here we're at the area of things to avoid. Avoid pronouns, avoid conjunctions, avoid orientation terms specifically the and that wherever you can. The next one, acronyms. Avoid acronyms at all costs. No matter if you know what the initials mean, unless the term is so synonymous with, unless the acronym is so synonymous with the actual name that everybody on the planet will know what it means, like USA, no one will trip over USA or USSR, but they will trip over RESPA, TILA, HOPA, FDCPA, FCRA. Every time you hear these, the mind has to stop and run through those letters and go in and do a transderivational search and pull out what those letters in that particular string refer to. And that always causes them to drop out of flow. It always trips them up in the reading. So if you're trying to make a complex point and you use an acronym in there, you get them halfway through the explanation and drop them out of flow. They got to figure out what that acronym means, and then they got to go back and try to recap and re-put together where they were when you dropped them out of flow. Avoid acronyms. Real Estate Settlement Procedures Act. That's a lot of words. However, when the reader sees Real Estate Settlement Procedures Act, the first time they have to read it. The second time, they'll recognize it like they recognize a Chevrolet. One eye fixation, and they got it. They don't have to read it. They recognize it. When we read, we don't look at a letter, elements, E-L-E-M-E. No, we don't do that. I look and I see elements on the screen, and I recognize it. Everybody's had the experience of seeing a word, and this little red flag pops up that says, wait a minute. There's something wrong with that. I'm just not sure exactly what it is. You have to look at it a bit to figure out where it's misspelled. The reason you knew something was wrong with it is because you had this picture in your head of what that word looked like. And then you saw this word, and it looked a whole lot like the picture, but your inner mind that does the comparison said, wait a minute, there's something doesn't match here. And that always trips you out of flow. Always run spell check on your documents. Misspelled words is a really big problem. I used to have a big problem with that, and I got untold grief about that. Now I am extremely careful about misspelled words because they kick you out of flow. Long sentences. Avoid long sentences. The mind just can't keep up with all those facts. If you have a sentence that takes more than 2 lines, it is way too long. Break that thing into 2 or 3 bite-sized pieces. You always want to write your document for an 8th grader. And it's not because your reader is not intelligent. We're writing legal documents here. And when we write legal documents, we tend to get into legal arguments that are necessarily complex. So it behooves us to eliminate all of the unnecessary complexity that we can. If we use a term that is industry specific or legally specific, those are called terms of art. Always define it. If there is a reasonable chance that this term can cause what we call a complex equivalent. Driver. When most people hear the term driver, it creates a meaning in their mind. They have developed this meaning for that term and when the term is used in common language. But in law, in court, they don't speak English. They speak legalese. And when the prosecutor uses the term driver or the arresting officer, the police officer uses the term driver, he has a different meaning than the one you have. His meaning is a term of art that's specifically defined in code. So what we wind up with is a complex equivalent. We both think we're talking about the same things, but we're not. So anytime you use a term that has a special meaning in the context in which you're using it, make sure you put in parentheses behind it, just a real short what this term means in this context. This goes to another issue, one concerning flow. When you start writing a document, if you create a question in the mind of your reader and you did not know you were going to create that question in the mind of the reader. Your technology is not sophisticated enough. You need to go back and rewrite your document so that you can anticipate the questions you'll create in the mind of your reader. This gets a lot simpler if you write for an eighth grader level. You don't assume someone already has a sophisticated knowledge, because they may have a sophisticated knowledge. That doesn't always help when you're speaking to a specific area of law, because legal terminology can get so complex. In the passion of the moment, we can very easily misconstrue terms of art. Always define them if you use the same term over and over. RESPA. If I'm going to use RESPA, I'm writing a document primarily about the Real Estate Settlement Procedures Act. First time I put in RESPA, Real Estate Settlement Procedures Act, I'll put quotations behind it, RESPA. And I will probably do that 3 or 4 times. After I've done it 3 or 4 times, now the reader has seen it enough times that he will make the connection and not have to stop and say, now, wait a minute. Am I getting this right? And go back up the document and look to make sure what he's seeing here is not some minor variation on what he expects to see. Once you've seen it 3 or 4 times, then you can start slipping RESPA in there if you want to train your reader to understand RESPA. But in a legal document, it is never, ever necessary to use an acronym. It appears to save you a little typing, but in the end, it costs you flow. Okay. Never make a proactive statement of fact or law from your own mouth. This may not be the right place to put this, but it kind of falls in line. If you have a perceptive reader, like a judge, and you make a proactive statement of law out of your own mouth, the judge is going to trip over that, because he expects to hear law or read law in the language of the statute or the language of the case law. He doesn't expect you to say, the other side, the law requires him to do this or requires him to do that, or the courts have said he must act in this way or that way. He expects to see the courts said in Screws v. U.S. the following, and you make your statement of fact or law using the verbiage of the court so that you don't make that statement out of your own mouth. The judge will trip over that every time, and that's probably one of the biggest mistakes pro ses make when they write legal documents. Pro ses tend to think that all you have to do is make a convincing argument and you'll win your case. Not how it works in law. In law, the judge has 2 primary duties. He must determine the facts in accordance with the rules of evidence, then apply the law as it comes to him to the facts in the case. If you don't give him facts in law, he cannot rule in your favor. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. This is a little longer break, so a good time to go look at our sponsor page and help support this network. We'll be right back.
Should parents be fingerprinted to drop off their kids at daycare? Mississippi says yes, but only low-income parents are being targeted. I'm Dr. Catherine Albrecht, back with more on this privacy rights issue next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
In Mississippi, low-income parents are getting an ultimatum at daycare centers. Give up your biometric data or do without daycare. Under Mississippi's program, parents who receive state subsidies for childcare must have all 10 of their fingerprints scanned, with no exceptions. Wealthier parents who can afford to pay for daycare don't have to do this. State officials are trying to justify this policy by saying that poor parents could be committing fraud, but they're applying the policy to the innocent as well, of course. So when did the working poor become suspects? No parent in America should be treated like a criminal just to get child care. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm going to serve them.
To the head of government, them. Prosecute them.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're getting a lot of callers early on. So I will only do this first portion. It'll take 2 more segments to go through the don't do section. And since it'll take 2 more segments, that means I'm not going to get to the do section. Don't misconstrue that, but I couldn't help saying that. So I'm gonna finish up on the things to avoid, and then next time I'll do how to establish rapport. Here I'm going to finish up talking about mixing elements, emphasis, linguistic structures. So let me just get on into them. The next thing to look for is mixing elements, and a real problem I see with pro se documents. We mix statements of fact and statements of law with arguments and conclusions. For a non-professional, they can misconstrue what you're presenting, and a lot of these legal gurus who promote these various ideas, they tend to do this all the time. They will state their opinion as if it were fact or law, and they don't make clear distinctions. When you're writing for a professional reader, you have to be very careful. If you make a statement that is an argument or an opinion or a conclusion, and you present it as a statement, they'll trip over that every time. Most of the time, lawyers won't bring that out because they know the judge is going to see it and pay no attention to what you put in there. He'll ignore it. So be careful about statement of facts, arguments, and conclusions. And the way to keep those apart is if you write a statement and put behind it, so saith the legislature or so saith the courts, and the sentence makes sense, then it's a statement of law. If it doesn't make sense, you need to take that out of there or rewrite it so that it is a statement of law. If you write a statement of fact and you put behind it, in my opinion, and you read the sentence and it makes sense, then it's not a statement of fact. It's an argument or a conclusion. Take it out. Okay, enough with mixing elements. Emphasis. Big issue with pro se writers is they want to make sure you get it. And I struggle myself with this. I want to emphasize this word because, hey, guy, you're too dumb to get this. You need to understand this is the most important part of the sentence. When I read material that I'm already familiar with and someone has emphasized these things, it's horribly distracting. I see the emphasis and I have to ask myself, why did he emphasize this particular section? And then I look at it and I figure out why he emphasized it, and I think, well, I already got that. So he stopped me to figure out why he emphasized it and knocked me out of flow. Judges really don't like italics and all cap sections or bold sections in prose. If you're concerned with whether or not the reader will get the specific point, then you haven't constructed your presentation well. Go back and rewrite it so you can't miss it. But avoid emphasis. The only time I tend to use emphasis is where I have a quotation of a statute or a quotation of case law that has a bunch of information in it that doesn't have anything to do with what I need, but I can't take out everything because it takes the portion I need out of context. Or if I have a statute and I have section A, B, C, D, E, F, and the only one I care about is C, I'll emphasize C, but only slightly. Generally, I'll put it in italics so that the reader doesn't have to read all these others. It's clear that this is the one I'm referring to. So the only time I tend to use emphasis is to help the reader get to the point and not to help convince the reader of what I'm trying to present. Okay, now we're going to go to linguistic structures. This is one I could probably spend 2 days on, but I'll try to bring this down. I'm going to mention these structures, not so that you'll fully understand them, but just so you'll be aware that they exist. A lot of times you'll read your writing and something doesn't look right. And if you don't have a lot of structures in your mind to work from, it'd be hard to figure out what's wrong with it. And having some familiarity with these linguistic structures will be very helpful in not only correcting your writing, but better understanding other people's writings, especially when you get a document from a lawyer that's a piece of garbage. And I get lots of garbage from lawyers. First thing I'm going to go to is complex equivalence. And I've spoke to complex equivalences earlier. Be very careful of the terms of art that you use. Even when a term is not necessarily a term of art. When we have a term that is a nominalization is where you take a action, a verb or a verb phrase, and you turn it into a noun. He really makes me feel agitated or upset or unhappy. And we take that and we turn it into mad. And we put this word mad in there. He makes me mad. Well, actually, he causes you to feel in a certain way. And that's an action. And you turn it into something that has reality, like it's actually did something specifically to you. Be very careful about terms that take an action or an idea and turn it into a noun, because that tends to create a complex equivalent. When you take all of these details that you've left out, take the details, turn it into a specific word you can refer to it to, then you have a surface structure that says mad, and you have a deep structure that has a definition for you. Somebody else may have that same definition and they may not. So you wind up using a lot of terms, and you put the terms down and they mean one thing to you, and another person reads it and they think they fully understand it, but they've got different definitions than you had. So be careful about terms that people can define differently than you. If you use a term that you need to use for the flow of the document, but it can be misinterpreted, then you won't lose reader flow if you put parentheses behind it and put in a small explanation of what you mean by this term. You know, one of the things you see a lot in documents is, and I always start my documents this way. I, Randall Kelton, comma, hereinafter referred to as petitioner. Then I go on. Well, in the document, I will often, the first 3 or 4 times I refer to myself, I'll refer to myself as Randall Kelton, petitioner. About the third time, about 3 times I'll put in petitioner, then I'll stop using petitioner. So that now the reader saw it enough times that when he sees petitioner, he actually hears in his mind Randall Kelton, and we don't get these complex equivalents. Now that one's an obvious example. There are a lot more subtle examples of complex equivalences. And I spent a little time on complex equivalents because they are a big problem in writing cogent prose. Okay. Lack of specification. One of the things we use a lot are unspecified breaks. We're about to go to a specified break. We'll pick this up on the other side. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We got a full board there. And I will finish up. I've only got about 4 or 5 more. Okay, we are back. Randy Kelton, Rule of Law Radio, and I'll finish this up, this segment, and next Thursday or Friday, I'll talk about building rapport. Okay, unspecified. We start out with unspecified comparisons. In an unspecified comparison, a statement will use words to imply something and relies on the mind being too busy listening to the next words to really question the truth or logic of what was just heard. A comparison is made, but does not specify what it is being compared with. You may find you are much more. I don't like that one. Every day in every way, you are getting better and better. Now, that really sounds meaningful, but it really doesn't say anything. It doesn't say how you're getting better or why you're getting better. Okay, and the way to identify an unspecified comparison is by asking, better than what? Like, for better than what? More relaxed than what? Faster than what? You ask for more specificity on the quantifier. I need to find a better way to explain this one. I'll go on to the next one. Unspecified object. These are words that sound good, but are actually quite vague. Words like learnings, outcomes, resources, findings, consideration. They can be used to ground almost anything, which makes the suggestion bulletproof. By using inclusive words, a person can find closure from their own resources. And later on, we'll talk about artful vagueness and how we use unspecified objects to send the listener into their own mind to fill in the details that we leave out. Now, it's okay to do that so long as you're consciously aware that you're doing it. So we need to pay close attention to what we leave out of a presentation. You can get away with a whole lot more when you're just doing prose, when you're writing a story or just telling a story. But when you're writing a legal document, you have to be very conscious of what you put in and what you leave out. Unspecified verb. Verbs, these are verbs that sound good but are hard to pin down. The unconscious mind accepts the word in context and supplies its own meaning. Words such as wonder, change, understand, think. And for the most part, these terms are nominalizations, where wonder is a term we made up to describe a state of mind, a way of thinking. And if we use these unintentionally, we can create a situation to where our reader can come up with different meanings and understandings than we intended them to. So especially in legal writing, be very specific. And this is a primary reason I suggest do not use adverbs. Do not use pronouns. You use pronouns in front of a verb, it becomes essentially an unspecified verb, because you're not exactly clear what that action refers to. The reader can misconstrue who he, she, they, them refers to. Okay, implied cause and effect. This I see a lot in the Patriot movement writings. You hear these, there was a bankruptcy in 1931, therefore you cannot pay your debts. You can only extinguish a debt. I probably heard that 500 times. And I always think, what on earth are you talking about? And they state these as if they were facts, as if that bankruptcy necessarily led to the fact that I can't pay off a debt. I have no idea what that means. Every time I see that, it trips me up and I'm stopped. If they wanted me to understand what they're talking about, they need to fill in those spaces and say, this is how. And I kind of understand it. They go on to say you can't pay off a debt, you can only extinguish a debt because you don't have real money, which has real value. You only have these pieces of paper which don't actually have any value and are supposedly backed by the government. It's a complex argument, but they imply, they make the statement as if it were a fact that one thing leads directly to the next, leads directly to the next. If you go to Gene Keating's page, if it's still up, on the first page, he has 6 of these in a row. This happened, and because this happened, this is the case, and because this is the case, this is the case, and because this is the case, this is the case. I didn't buy the first one. And he's 6 unstated presuppositions down. I have no idea what he's talking about. I certainly can't accept his proposition because it's based on these assertions of fact and implied causes and effect that I don't have the details to make sure that they all fit in place. Anyway, I got to work out how to present that better. I'm sure I've got everybody thoroughly confused now. Now we'll go to lost performatives. In the lost performative, you state that something happened and you don't state how. A suggestion is presented stating that some opinion is true, but does not say how it is known to be true or who is saying it. Speaker expects the individual will accept the statement as being self-evident and not ask for proof or examples. This I get a lot from prosecutors. Prosecutors make statements to juries all of the time about what the law says and what the law means without showing how they got to these meanings. And those should always be objected to. And, okay, and a loss performative, you can test a loss performative by taking their statement and put behind it says who. If somebody states that something is so and it makes sense for you to put says who behind it, then it has a loss performative. Next one is a non sequitur. Non sequitur is a big problem in pro se writings. A non sequitur means that in a logical syllogism, you tend to have one fact that follows from the other. If A equals B and B equals C, then C equals A. Well, what if A doesn't equal to B? If you do this, it will cause this effect. And if you have this effect, it will cause this effect. Therefore, if you have the first effect, you'll have the third effect. Maybe. If your logic does not lead necessarily to your conclusion, it's a non sequitur. And pro ses do this all the time, where they say, because of this, that happened, because of this happened. Therefore, if this never happened, this third thing wouldn't happen. So we need to go back here and fix this problem that never was a problem. Okay, I got to get a better way to explain non sequitur. I'm going to finish this off. I'm not going to go into extended quotations. There are a number of other somewhat more minor don't do so, but I could probably spend another hour stumbling around here trying to explain stuff I'm not getting explained very well. I'm doing this because each time I do this, I get a little better at presenting it. And I'm going to turn this into an ebook that you can download and go through these pieces. And I'm hoping that I'm structuring it in a way that you can find what you need when you need it. In process of doing this, I'm developing a somewhat different technology that should adapt more to the way human beings do what human beings do, so that you can mine through all of this information you don't need to find what you do need. Okay, well, I'm going to stop stumbling around for the moment. Next Thursday, I will go into building rapport, and from that we'll go to artful vagueness, and then we'll go to where to start, where to end, how to actually build a document. So maybe I'll get through that next Thursday. It should take probably 2 hours to go through that part. Okay, I'm going to stop babbling for the moment and go to our callers. I'm going to go to Andrew in Pennsylvania. Hello, Andrew. Have I thoroughly confused everybody?
What? Did you confuse everybody? No, you didn't.
Well, I confused me. So I guess that's enough. Okay, what do you have for us tonight?
Yeah. Well, first of all, we're about to go to break. Well, all right, I'll quickly point this out. Maybe we can talk about the other side. The thing with Arizona, lawyer said he can get one charge dropped, get it down to criminal speed, but he'll try to get it down to more. Well, I just thought I'd point that out because I've talked about that the last couple shows. I do actually have a little bit of a question for you, Randy.
Okay. We'll have to go to break. We'll pick this up on the other side. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. This is a long top-of-the-hour break, so it's a good time to go to logosradionetwork.com or to ruleoflawradio.com and check out our sponsors and patronize our sponsors. It'll help support this network, and right now we need all the income we can get to keep things on the air. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Andrew in Pennsylvania. Okay, Andrew, you had a question.
Yeah. Oh, just one more quick pointer about the Arizona thing. Lawyer's still going to fight it, try to maybe get it down to a civil thing. I almost lost my lawyer, actually, when I did something he didn't approve of while he was at the pretrial conference. I filed a motion for removal to federal court on grounds of diversity jurisdiction papers, and after I told him, by the way, I did that, he didn't seem to approve of it, and he threatened to leave me, and that's how I learned that when you have a lawyer, it's really not a good idea to try to make it two heads are better than one thing out of it and try to fight it at your end. You better just let your lawyer do his thing. Is that a good way of looking at it, Randy, first of all? You shouldn't.
Yeah, and that's right. If you want something filed, you go to your lawyer first and try to get him to file it. If he refuses to file it and you're sure it needs to be filed, then, if necessary, you can file it yourself. Or you can tell the bar, one thing about your attorney, once he's your attorney, it's not so easy for him to just walk away. Now, they're used to being able to walk away, but they're not accustomed to litigants objecting to their motion for removal, for withdrawal. We just had someone in a bankruptcy case object to the lawyer's motion to withdraw. And the judge said, well, Ms. Ortiz, it seems that you're unhappy with your lawyer. It doesn't make any difference if I'm unhappy with my lawyer. I paid him. He has a job to do. And the judge told the lawyer, he said, well, counselor, you're going to have to work this out with your client. The judge got it. The lawyer's under contract, and the judge has no power to interfere with a private contract. Anyway, go ahead. You had a question.
Yeah. The other question I wanted to ask is, why would it be a bad idea to try to invoke God at trial when you can prove what God is and that God does exist?
What does that have to do with the case?
But no. It's a completely unrelated issue. Yeah.
Okay.
I wanted to ask.
Yeah, okay. That's one of the things that I'll talk about in building documents. Now, you may have a really great argument, but if it doesn't go to the jury charge, when you like in this case, you have a criminal accusation, you need to read the pattern jury charge for that criminal accusation. Pattern jury charge is, what is the judge going to say to the jury before he sends them out to deliberate? He's going to say, you must find this element and this element and this element. If you fail to find all three elements, you must acquit. So you need to know what those are. And then when you write any kind of argument into a document, if it does not go to disproving one of those elements, or if you're the plaintiff in a civil action, if it doesn't go to proving one of those elements, take it out. Has no business in there. Okay, so I think maybe I misconstrued where that came from. You weren't saying that had anything to do with your case, were you?
No, well,
or did I misunderstand?
No. Randy, can you hear me?
Yes.
Can you hear me? Oh, okay. Well, that whole question about God and why you can't invoke it during trial came from way back in the day when I asked you about the One People's Public Trust thing, where these people claim to have foreclosed against the government, the banks, and everything, and their assertion is based on the fact that everything comes. The states of people are the creator. Lawfully speaking, there's nothing higher than the One People's Public Trust except the creator. And then you said, well, the first problem is you can't invoke God. Well, I think, if you can prove what God is and that God actually exists, and if you don't want me to argue this on your show because it might make the Christians unhappy or whatever, then I won't do that.
No, I don't have a problem with that. It's just I don't want people to misconstrue how you fight a legal argument. And we've had people come on the show and say that they're using God's law, and I want to remind them what God said about that, or what Jesus said about that. He said, "Render unto Caesar." In court, we're not under God's law. We're under the law that we as human beings created. And that law is our law. And God don't have anything to do with that. He stepped back and he let us use that power of divination he gave us to create restrictions on ourselves. And when we go into court, we are in court under a set of statutes that we have in one way or another bound ourselves to. The penal statutes we bind ourselves to by virtue of our citizenship and our presence within the jurisdiction. There are other statutes that we bind ourselves to, like any license that you get binds yourself to a set of rules. And once you've bound yourself to those rules, you can't go in and argue a different set of rules. Does that make sense?
Yeah, and getting back to the thing with Arizona, I never showed the license that I had. I wasn't in a commercial capacity, so that's the key. You got to be in a capacity. It's not just possessing a license. And I said I wasn't going to show it, but the officer, when I was in cuffs against my will, took the license out of my wallet and got the number down on the paper. And my lawyer told me that, and I told him, well, they did that against my will, and I can't actually really prove that because my camera stopped rolling after the cops.
Okay, hold on. Question.
Yeah.
This is the question you should always ask after you state a claim. And this is what the judge is going to say. Okay, so what? And that means, how were you harmed by this act?
Well, when the officer yanked me out of the car, didn't he commit aggravated assault with a deadly weapon, which would be 20 years to life?
Separate issue.
Okay.
You raised the issue of him taking, you wouldn't give him your license, and he took your license once he arrested you. How were you harmed by that?
Rights violated.
How? Harm is not that's a term of art. Harm means harmed in a legal capacity, harmed in a way for which you have a right to remedy. And all your rights to remedy are defined by causes of action. When you violate a penal statute, the violation of the penal statute is a cause of action that the state has. Any civil claim, you can't just say he did something wrong and harmed me. You have to state your claim in terms of a defined cause of action. So what would be your cause of action? I'm thinking due process, but nah, he really didn't deny you any specific right. He didn't incarcerate you because of that. He didn't write you a separate citation. Now, if he took that license when he had no authority to do so, and then say that your license was expired, then that goes to fruit of the poison tree. Then you could challenge the evidence. But in this case, where you didn't want him to see your license, and he arrested you, and once he arrested you, then he has a right to search, and in the process of search, he comes across this license, and he looks at it. How are you harmed?
Okay, well, you kind of lost me, to be honest with you, when you said he has a right to search. What about the whole thing about needing to get probable cause on a warrant?
That's a different issue, and that's one of the things we have to be very careful about, mixing up issues. Now, arrest without a warrant, that's an issue. Arrest without probable cause, that's an issue. That doesn't go to him looking at your license. Am I making sense? It's all about making sure we make the right argument.
Okay. So how was I harmed when he took the license out of me against my will? Well, I was harmed because well, it's a good thing I ordered Jurisdictionary yesterday.
Exactly. Oh, wonderful. Because Jurisdictionary, it's not that you can't show that you were harmed. I was denied access to a court recently when the prosecutor asked if I was a witness, and I said I have no personal knowledge of anything that went on this traffic citation. Well, if you were called to as a witness, would you be willing to testify? I said, of course. I'm not going to jail for contempt of court. So he said I invoked the rule. He threw us out. Denied me access to the court on false pretenses. Well, I have a right to a public court, 1.27 Texas Code of Criminal Procedure. And that right is protected by Article 1, Paragraph 10, Texas Constitution. He denied me in a right to witness a court proceeding. Now, maybe that's not a big deal for him. To me, it was a very big deal because I paid for that right. And I can tell you, I paid heavy for that right. And for him to capriciously and arbitrarily take away a right that I paid so much for, that is a big deal. So I am harmed by a denial of due process. Am I making sense? Yeah, and they can do something that don't mean much to them. When a policeman pulls me over and asks me for my proof of insurance, and I tell him no, and he puts his hand on a pistol, that is a really, really big deal. I consider that assault with a deadly weapon. Now, he may not think that's a big deal. He does that all the time. But I spend time on the sharp end of those things. Those things are a really big deal for me. So it's a great harm to me for a policeman to put his hand on his pistol in a threatening gesture while he's prominently displaying a deadly weapon. There are a lot of good things we can get him for, but always you got to think, how am I harmed by this? Or how can I frame this so it has the appearance of harm? Because in the end, appearance is everything. The perception is everything. Hang on. About to go to break. Randy Kelton, Rules Our Radio. Our call-in number 512-646-1984. And we'll get back to you on the other side, and I'll try not to talk so much, Andrew. We'll be right back.
Now.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took money from my hand.
Okay, we are back. Randy Kelton, Rules Our Radio, and we're talking to Andrew in Pennsylvania. Okay, Andrew, I'm going to shut up and let you talk.
Yeah, all right. Completely unrelated issue. This is my last question, and then I'll call it a night with you. It's kind of fitting. One of the commercials during the break was about the Michael Muris debt collection thing, because I wanted to ask you a question about how we should – let's imagine for a moment that the dollar will crash this year, will totally lose its value. There's going to be some gold or silver-backed currency release. But let's imagine that – how do you prepare for something like that? Well, let's say if you could perfectly time when the dollar is going to be officially dead and be replaced by currency, is it a good idea for us to all max out all of our credit cards to buy as much gold and silver as possible, take out as many loans from as many banks as possible, use all that money, all that loan money that we got to buy gold, silver, and other economic collapse survival supplies, and then when the dollar collapses, it'll all work out nicely, and we'll get to keep all that without paying that debt back because the dollar collapses, so all debts are officially canceled. Is that a good or a bad idea?
I would say, based on that premise, yes, it would be a good idea. If the dollar collapses and you expect it to hyperinflate, then you want to get your money out of those green dollars and into something hard, something you can hold in your hand and touch. You know, I have this coffee cup here in my hand, and it takes a certain amount of material and a certain amount of labor to produce this coffee cup. No matter what happens to the dollar, it's going to take the same amount of material and labor to make this coffee cup. So this coffee cup is not going to change in value. Now, it may take a whole lot more dollars to buy it. So if the dollar were about to go into hyperinflation, then gold, silver, platinum, palladium, lead, there are a lot of things you could put it into, but primarily things that are hard. But we had one guy that used to come on the show a lot, and he was buying up machinery. Because at the time, it was right after NAFTA got put in, and what Ross Perot said happened. He said, if you pass NAFTA and listen real closely, you'll hear a large sucking sound, and that's all of the jobs being sucked out of this country, and that's exactly what happened. Well, this guy's buying up all the machinery. It's selling for pennies on the dollar, putting them in warehouses. They're hard. Whatever happens to the dollar, these things are going to stay essentially the same value, and he bought them undervalued. So now he waits for the dollar to crash, or in his case, he's waiting for the manufacturing environment to turn around. And if the dollar crashes, then it would make it much cheaper to buy our products. So manufacturing would start again, everybody buy his machinery. So yeah, I would say that would be a great idea.
All right, so let's max out all our credit cards on gold and silver.
Okay, hold on. With that said, my son asked me a question about hyperinflation of the U.S. dollar. One question really put it into perspective. what would the U.S. dollar hyperinflate against? In order for it to hyperinflate, it has to hyperinflate relative to another currency. What would it hyperinflate against? The euro is in the toilet. The yuan, China, is about to go into a major economic crash. Ours is the only one stable. I can't see any way the dollar can hyperinflate. One of the good things about this country is countries all over the world have made major investments in the United States, including China. So the last thing they want to happen is for our dollar to crash. So they lose all their investments. And in order for our dollar to crash, some other currency is going to have to come up and take its place. And in about 5 to 7 years, I expect the yuan to wind up the universal currency. It's going to take the place of the dollar. But it's going to take 5 to 7 years. China's going to have a major crash because they subsidize so much of this growth. Now the same thing's happening to them that happened to Japan. It's catching up with them, and they're beginning to crash. So they're going to crash, and they got all of this infrastructure they built, and then they're going to get busy, fill up that infrastructure. Once their currency has crashed, it's not worth much, companies can come in and invest in this infrastructure cheap, get them all of this filled up, get their production back in place, and when they rise up, they will become by far the most powerful economic engine on the planet. But they've got a cycle they have to go through first. So next 5 to 7 years, I can't see anything that would crash our dollar.
Really? Well, someone on the Alex Jones show a couple years ago did say when the Federal Reserve raises interest rates, watch out for like a Great Depression in the Federal Reserve recently.
You know how long I've been hearing this stuff? 40 years I've been hearing it. Since George Brown back in 71, 72 was saying, convert all your money to gold, the dollar's going to crash. I've been hearing it since the 70s. Don't see it. There's nothing for it to crash against. I can't see it happening now, in spite of the dire predictions. There's always somebody out there making these dire predictions. So I would definitely be careful about betting on running up all your credit cards. Now, we can't say this on the air because it would be inappropriate. But if your credit cards were all run up real high and the debt collector didn't follow the rules in collecting the debt, and you sued the crapola out of him using jurisdictionary and Mike Mears' methods, a good chance you could make all that debt go away. But I certainly wouldn't advocate anybody running up a credit card so they could do that. That would be so unfair to those poor debt collectors. And they got to eat too. So using these tools, but that's totally separate from how the economy actually works. We have stuff we can throw at the debt collectors because they don't do anything right, but they don't have anything to do with the economy. I certainly wouldn't suggest that somebody take this gamble at this moment, because with the interest you pay, you'd be assessed on the credit cards. It'd be 5 to 7 years at least before they get that back. And by then, they'd be eat up with interest costs. I don't see it as a good investment. But then I'm not the economic guy either, so take my advice for what it's worth and not a whole lot.
Thanks, Randy. All right. Thanks for taking my call.
Okay. Thank you, Andrew. Okay, now we're going to go to Chris in Pennsylvania. Hello, Chris. How are things going with your mortgage issue?
All right, I guess. I don't know if you got a chance to look at the email I sent you.
Oh, I didn't notice one from you. When did you send it?
Probably this afternoon, earlier today.
Okay, I probably didn't get to it. I was working on a very complex spreadsheet that gave me a very big headache, so I probably didn't get to it yet.
No, that's okay. We talked last week about the summary judgment they gave and looking at the actual ruling the judge passed for the reason for the summary judgment. And it came down to the fact that my attorney failed to file a brief on time. he passed it.
So he filed a brief out of time. How did he manage to do that?
She actually filed an answer to the summary judgment in the...
Okay. Hang on, Randy Kelton, Rule Law Radio. Call in number 512-646-1984. We'll be right back.
What do you do when a bird with a broken wing waddles into your oven and refuses to leave? I'm Dr. Catherine Albrecht, back with the tale of how one Austrian couple faced exactly that dilemma. Next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Here's a love story from Austria that involves a taxidermist named Bertel Reiterer, his wife Ermi, and a pigeon named Susie. It started the day Bertel found Susie with a broken wing by the side of the road. He took her to a vet, then home, then set the bird up in the garage. But on Christmas Day, Susie waddled into the kitchen, hopped into the oven, and refused to come out. Rather than make pigeon stew, the couple adopted Susie and allowed the flightless bird to make a home in their oven. That was 17 years ago. Sure, it makes cooking tricky, they say, but their kitchen is all the warmer for it. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule Law Radio, and we're talking to Chris in Pennsylvania. Okay, go ahead, Chris.
She failed to send in a brief, even though she sent in a response to the summary judgment. The response was to the allegations they made for summary judgment, and she admitted, denied them, and put in exhibits of evidence. And in the evidence, said she was going to file the brief at the conclusion, and didn't get that in, I guess. So the judge decided for the bank on the summary judgment based on the fact that she didn't file a brief in time. And she's found that that is not, in fact, the case. A judgment can't be made on that conclusion. She can be sanctioned for that, but he cannot make the determination of summary judgment based on failing to file a brief.
That was going to be my question. The first thing I would ask the judge is for findings of fact and conclusions at law. So what are the facts and law on which he based the ruling? And not filing a brief. Now, if this were an appeal, that can happen. We just talked about that happening to someone last night. But this is not an appellate brief. This is a motion. And as far as I know, generally you file in opposition to the motion, and you don't necessarily file a brief unless the court asks for it or directs you to file a brief. I know I've responded to lots of summary judgment motions without a brief in support.
Right, and that's what she was figuring on as well. So her plan was to file a motion to strike the summary judgment based on that, and see where we go from there.
Wait, motion to strike the ruling.
The ruling, correct.
Hold on. That doesn't fit right. Motion for reconsideration.
Okay, for reconsideration.
Yeah, she wouldn't ask the judge to strike his own ruling. She would ask him to reconsider the ruling. If she asked the judge to strike his own ruling, he's likely to strike her.
Right.
It's just a protocol. Right. So, and good chance he will overturn if she gives him good case law as to why.
Yeah, and that's the other thing as well. I mean, she's basing this all on the case law, and in Pennsylvania there just isn't any good case law. Pennsylvania is merely making conclusion that if a bank is holding a note or a mortgage, rather, that they have just cause to foreclose, whether it's good mortgage assignment or not. Even though we have in our an appeal to the summary judgment, the fact that the bank is stating they are merely the servicer for the lender, Fannie Mae. So couldn't quite get by how they even have subject matter to bring this foreclosure, since they're even making these assumptions, one, that they have the note and mortgage in their name, and the other one that the bank is merely the servicer.
So it's unclear who is the holder.
As far as what the bank is saying, yes. Even though they purport to saying they have the note and the mortgage, which they've taken during the bank.
Did you ask to see the note?
We did, and supposedly they brought the note to court.
Did your lawyer examine it?
As far as I know, she did. She said it was stamped original, and it was the 7x14 size paper our copy appears to be like.
Was it endorsed?
No, it was in blank.
So were there any allonges?
None.
You have reason to believe that the note was negotiated into a security?
Correct.
Wait a minute. Your original lender was Wachovia.
Correct.
Then nobody actually holds the note, just whoever happens to have it in their hand. Is that what the position of... Wait a minute. That note has been discharged in bankruptcy.
Correct.
So has your lawyer objected to any reference to the note?
Yes.
It's irrelevant.
She's made the claim that it was discharged in the bankruptcy, and it appears not to be an issue here. It appears that the judge, all case law that we run up against here is giving favor to the person holding the mortgage.
Okay, now that the underlying debt has been discharged, then the mortgage contains no claim.
Correct.
So your position now is that you have filed a quiet title action against the mortgage. Is that correct?
That's our plan. Yes, that's what we're doing as we speak.
Oh, good. Okay. So what is the case that's in court now?
The case that's in court now is just the foreclosure. We've gotten the summary judgment, so we're attempting to ask.
Okay. So you're appealing the summary. You're asking for a motion for reconsideration, and then you appeal that ruling. And in the meantime, you're running the quiet title action against the deed of trust, the mortgage in the background.
Correct.
So if you get your quiet title ruling in your favor, then you can go to this court and res judicata, move to dismiss for lack of a claim.
Correct.
Oh, wonderful. So the fact that, go ahead.
The interesting part is that there's no case law that shows that. We've looked at several instances where people have tried the same thing, and for a reason I'm unsure, there are case law where, given in the conclusion, the attorney speaking about the case, or the judge who gives their I forget the name they call her demise at the end of the case. Someone will tell them how the case went wrong or what they believe should have happened. In most case law, they give that conclusion. Most of what we're reading is that these cases have failed for the very reason that none of that was established, and that case law clearly makes this statement. But for some reason in Pennsylvania, they're just not ruling that way.
Well, I don't understand how this stays in Pennsylvania, since the prohibition is federal.
Right.
Okay, for those who are not familiar, he had this discharge in bankruptcy, and the bankruptcy code forbids anyone from attempting to prosecute a security instrument for a debt that was discharged in bankruptcy. It strictly forbids it. So that's federal. How is this even in the state court?
I'm not sure.
Because of that federal prohibition, that should have bounced it out to the federal court. The federal court's more likely to rule in favor of their own law than the state court is.
Mm-hmm.
And it might be, okay, they filed, what was the timing? When did they file for foreclosure?
They filed for foreclosure. We got our Act 6 notice.
Okay, wait. Let me re-ask that question in context. When did they file for foreclosure relative to the bankruptcy discharge?
After the bankruptcy discharge, they filed for foreclosure.
Okay. Hang on. Randy Kelton, Rule About Radio. Our call-in number, 512-646-1984. We'll be right back. Okay, we are back. Randy Kelton, Real Raw Radio, and we're talking to Chris in Pennsylvania. Yeah, but in the end, it probably doesn't matter if it's in state or federal court, because the federal court will still govern that issue. And you do have the issue before the court. So all this other wrangling it sounds like the other side probably knows they're going to lose, and they're hoping that they can outmaneuver you on the rules of court. A friend of mine lost in exactly that way, really subtle way. They filed for informa pauperis. The other lawyer and them wrangled back and forth, and finally they said, enough of this argument over that. We'll just go ahead and pay the filing fee and get this thing over with. So they paid the filing fee, and the judge dismissed immediately, because once they paid the filing fee and dismissed the informa pauperis, it was out of time to pay the filing fee. So they may be hoping they can get you on procedure, what they've lost otherwise.
Mm-hmm.
So be careful with procedure.
Yeah, the other part of this that I was looking at trying to make a point with, I don't know if it's a relevant point, is determining whether or not the bank, we looked at a few cases that had this 401 ruling on an Act 6, where the bank was said to have made the Act 6 claim to us prior to being the lender. And we noted that even though 401 made it very clear that you couldn't come in and give an Act 6 notice without being the lender, the rulings in this state have still negated that and just went along with rulings in favor of the bank.
It would seem you could appeal it to even if they rule that way, you could still appeal it out to the Fed on showing that the state was rendering rulings that were not in comporting to federal law.
Right.
So this sounds like you've got the facts and the law on your side, and the other side's trying to just hoping they can get you to screw up on procedure.
Mm-hmm.
So be careful with procedure. Make sure you get all your filings in on time. They're hoping for something just like what they got here, where the lawyer didn't get the brief in on time. And you might remind your lawyer that if she loses this case for you because of what she failed to do, then she's liable for the whole amount in a malpractice suit.
Right. Right. We were looking at another issue as well. Now, I don't know if these things become pertinent to insurance claims. I discussed with you last weekend about Wells Fargo finally being sued by the government, or finally coming to some fruition as to the cause of the collapse of the market, which was to find them and other banks responsible for taking these fraudulent loans and then taking out the insurance policy and claiming them on the FHA loans. And they just got sued for that and had to come forward with a $1.2 billion settlement. Does anything occurring with a settlement, or not with a settlement, but with an insurance claim, predetermine that the bank has already been paid and they can't be paid twice by foreclosing?
No. Not that I know of. An insurance claim is like playing poker. Years ago, I had a business partner who had someone break in his house and steal his really expensive stereo set. 3 or 4 days later, the insurance company came and wrote him a check. He was just thrilled at how quick they were. And a couple of weeks later, the police recovered his stereo set. They brought it back to him. And he called the insurance company. He said, "Hey, guys, I got your stereo set." I said, "That's not ours, that's yours." I said, "Yeah, but you paid for it." They said, "No, we didn't." So you bought an insurance policy and you bet that it wouldn't get stolen. Or you bet that it would get stolen. We bet that it wouldn't get stolen. We lost. So we merely paid on our policy insuring it against being stolen. We didn't buy it. So it's still yours. So he got paid for it. The insurance paid off and he got it all back, got to keep it. Point is, what was paid to Wells Fargo from the insurance company was between the insurance company and Wells Fargo. Wells Fargo took money it had and paid this insurance company for a policy and made a bet that this note would default. The insurance company made a bet that it wouldn't. Insurance company lost the bet. You don't have it. As far as I know, it doesn't affect you in any way. Does that make sense?
Yeah, that makes sense. We were just looking at, some kind of ruling where the bank's already been paid or the debt's been paid through the insurance policy. And if the insurance company pays, kind of like if I have a car repossessed, then the car goes to the insurance company or it goes back to whomever, who held the insurance, or if the car is totaled.
Okay, that's specific to automobile. The policy itself has that provision in it. And if they total the car and pay it off, they keep the car. That's in the contract, though.
Right, okay.
But even if it was in the contract with Wells Fargo, that contract is between Wells Fargo and the insurance company, and you don't have anything to do with it.
Okay.
So whatever happens there, you can't get a claim because the mortgage wasn't paid. The insurance company paid off on the bet. So that won't help.
So we're really looking at this thing as being a federal issue with the bankruptcy then. What this?
I would have thought so, but your lawyer may have had a good reason to want to keep it in the state. At this point, it sounds like not such a good reason.
No,
because you're more likely to have gotten a positive reading on this bankruptcy statute prohibition in the federal court because it's a federal law.
Right.
But in any case, you'll be able to appeal it to the Fed. Since it's based on a federal question, you'll definitely be able to appeal to the Fed.
Right.
And I probably need to explain this to those who don't understand how this works. In 2011, the legislature passed the Venue and Removal Clarification Act. Prior to this time, there was a split between the circuits. Some of the circuits said that if a case has state and federal issues in it, and it is removed to the Fed, then the Fed can hear both the state and federal issues under judicial economy. And then the other circuit said, no, the Feds can't hear the state issue. That's an unwarranted preemption of state law, of state authority. So the legislature weighed in and passed the Venue and Removal Clarification Act and said that while a case with state and federal issues can be removed to the federal court, the federal court must sever the state issues and remand. Okay. In this case, the state law doesn't address that issue. The state law doesn't necessarily say that a state judge cannot hear a federal issue. And that's the way it's always been. That's 200 years of law. This clarification by the legislature changed 200 years of law. It used to be if it's in the state court, the state hears both. If it's in the federal court, the feds hear both. Now the feds can't hear both. They have to send the state back down. But as far as I know, there's nothing in the state that says we can't hear both state and federal issues. And the feds don't care so long as the state rules in accordance with federal law, because you get your remedy. But if they rule against you, then you can definitely rule it to the Fed, because that statute is a federal statute. Okay, did that make sense?
Mm-hmm. That made perfect sense.
Okay, do you have any other questions or comments?
One more question. Based on our Wachovia experience with this, and the bank not being, I've been doing a lot of kind of bickering back and forth with the attorney. Her thoughts are, because Wachovia Mortgage Corporation still has a website up, that Wachovia Mortgage Corporation is still in existence. And to be able to fight the fact that MERS passing the assignment on as nominee for Wachovia wouldn't be a good thing, because she thinks Wachovia Mortgage Corporation is still in existence. Now, the website, when you check it out, has no administrators, has no nothing to it. It is merely a hotline phone number to Wells Fargo Home Mortgage.
She's probably right. Okay, let's pick this up on the other side, but need to move quickly. We've got a full board of callers. This is going to the top of the hour break, so this is our 3-minute break. Good time to go look at our gun giveaway. We have our fundraiser on, and we have another special gun giveaway. Look at Juris Dictionary and Mike Maris Method and our other sponsors. Anything you can use that we have available would greatly help us, because we only get paid from those sponsors when one of our clients or customers or listeners buys from them. And right now, we need all the funds we can get. We're really struggling to keep this network on the air. We'll be right back.